The title of this video is Ramifications of States' Detrimental Contracts. Introduction and objective of this video. Greetings, and welcome to this discussion. Before we delve into the topic, I want to make it clear that I am not a legal professional. The insights and information I will be sharing today have been generated with the help of AI. This video is intended to raise awareness and initiate a conversation among Pakistani legal professionals and policymakers about the serious issue of detrimental agreements between companies and the state. The goal here is to encourage a thorough discussion and legal examination by those who are qualified to do so. Please keep in mind that this is not legal advice, but rather a call to action for the appropriate authorities to consider the matter further. We asked the following 6 questions to artificial intelligence. Question 1. What types of contracts should be identified when companies manage to secure agreements with the government that ultimately prove detrimental to the state? Additionally, are these agreements challengeable in court, and under what legal grounds can they be contested? Question 2. In cases where contracts are found to be detrimental to the state, can the state bureaucracy, financial consultants, transaction advisors, accountants, legal advisors, and other professionals representing the government be held accountable for their roles in facilitating such agreements? What are the possible legal and ethical responsibilities they may face? Question 3. Should shareholders, financial consultants, transaction advisors, accountants, financial advisors, and lawyers representing the companies involved in securing these detrimental agreements be held responsible for their roles? What are the potential consequences and liabilities they might encounter for facilitating such contracts? Question 4. What were the responsibilities of the people in power at the time, including the members of the respective cabinets who approved these agreements, if such approval was required? How should they have exercised their authority to protect the state's interests, and what accountability measures should be in place? Question 5. Can the Supreme Court of Pakistan take suo motu action upon becoming publicly aware of agreements that are detrimental to the state? What legal basis and precedents exist for the court to intervene in such matters to safeguard public interest? Question 6. What steps should the public, legal professionals, and bar councils take to protect the public from the adverse effects of agreements that are detrimental to the state and its people? How can they effectively challenge such agreements and hold those responsible accountable? Question 1. What types of contracts should be identified when companies manage to secure agreements with the government that ultimately prove detrimental to the state? Additionally, are these agreements challengeable in court, and under what legal grounds can they be contested? Understanding detrimental government contracts. When companies secure agreements with the government that later prove harmful to the state, it raises significant concerns about the nature of these contracts and their impact on the public. It's essential to identify the types of contracts that fall into this category and understand the legal avenues available for challenging them. Types of detrimental contracts. 1. Unconscionable contracts. Definition. These are agreements where the terms are so unfair and one-sided that they heavily favor the company at the expense of the state. Such contracts often exploit the power imbalance between the government and the private entity, leading to significant losses or disadvantages for the state. Characteristics. These contracts might involve excessive pricing, unfavorable clauses, or conditions that are not in line with the public interest. 2. Contracts against public policy. Definition. Agreements that violate established public policy or legal standards are considered void or voidable. These contracts might undermine the state's economic stability, security, or overall welfare. Impact. Such contracts are often detrimental because they prioritize private gain over the collective good, leading to long-term negative effects on the state and its citizens. 3. Ultra vires contracts. Definition. Ultra vires is a legal term meaning beyond the powers. If a government body enters into a contract without the proper authority or outside its legal powers, the contract can be deemed ultra vires. Implications. These contracts are particularly problematic as they may be entered into without proper oversight or legal basis, making them susceptible to legal challenges. 4. Fraudulent or corrupt contracts. Definition. Contracts that involve fraud, misrepresentation, or corruption are inherently detrimental. These agreements are often secured through illegal means, such as bribery or deception, and they serve the interests of a few at the expense of the state. Consequences. These contracts not only harm the state's financial interests but also erode public trust in government institutions. Challenging detrimental contracts in court. 1. Legal grounds for contesting contracts. Unconscionability. If a contract is found to be unconscionable, a court may void the agreement or amend its terms to ensure fairness. The court considers whether the contract was entered into under undue influence, deception, or a significant power imbalance. Violation of public policy. Contracts that contravene public policy are challengeable in court. The state or affected parties can argue that the contract is void because it conflicts with legal standards or public interests. Ultra vires doctrine. If a contract is ultra vires, it can be declared invalid by the courts. This legal ground is often used when a government agency oversteps its legal authority in entering into a contract. Fraud and corruption. Contracts secured through fraudulent or corrupt practices are voidable. Legal actions can be taken to annul these agreements and seek restitution for any losses incurred by the state. 2. Potential outcomes in court. Nullification of contracts. The court may declare a contract null and void, rendering it unenforceable. This outcome is common when the agreement is found to be ultra vires or against public policy. Rescission. The court may order the rescission of the contract, effectively cancelling it and restoring the parties to their original positions. Damages and restitution. In cases where the state has suffered financial loss due to a detrimental contract, the court may award damages or order restitution to compensate for the losses. Conclusion of answer to question 1. Safeguarding the public interest. Identifying and challenging contracts that are detrimental to the state is crucial for maintaining the integrity of government operations and protecting public resources. By understanding the types of contracts that pose risks and the legal grounds for contesting them, we can ensure that the state and its citizens are not unduly harmed by unfair agreements. It is the responsibility of the legal system, government officials, and vigilant citizens to hold those accountable who engage in such practices and to safeguard the public interest. Question 2. In cases where contracts are found to be detrimental to the state, can the state bureaucracy, financial consultants, transaction advisors, accountants, legal advisors, and other professionals representing the government be held accountable for their roles in facilitating such agreements? What are the possible legal and ethical responsibilities they may face? Accountability in detrimental state contracts. When contracts are found to be detrimental to the state, the spotlight often turns to those who facilitated these agreements. The state bureaucracy, financial consultants, transaction advisors, accountants, legal advisors, and other professionals involved in the process can indeed be held accountable for their roles. Let's explore how and why they can be held responsible, and the legal and ethical responsibilities they may face. We will discuss the following: legal accountability, understanding the risks, ethical responsibilities, upholding integrity, consequences of failing to uphold responsibilities. Legal accountability, understanding the risks. 1. Breach of duty, duty of care. Professionals like financial consultants, accountants, and legal advisors have a duty of care to the state. They are expected to act with a reasonable level of competence, diligence, and integrity when advising or facilitating contracts. Consequences of breach. If it is found that these professionals failed to perform their duties competently or acted negligently, they could be held liable for any losses or damages incurred by the state. This could lead to lawsuits, financial penalties, or even criminal charges in severe cases. 2. Criminal liability, corruption and fraud. If any professional involved in facilitating the contract engaged in corrupt practices, such as accepting bribes, falsifying documents, or intentionally misleading the government, they could face criminal prosecution. This may include charges of fraud, corruption, conspiracy, or misconduct in public office. Severe penalties. Criminal liability could lead to imprisonment, hefty fines, and a permanent stain on the professional's career and reputation. 3. Civil liability. Negligence claims. The state can bring civil claims against professionals who were negligent in their duties. For instance, if an accountant or financial consultant provided flawed financial advice that led to a detrimental contract, they could be sued for damages. Compensation. Civil courts may order these professionals to compensate the state for any financial losses or damages resulting from their negligence. Ethical responsibilities, upholding integrity. 1. Professional ethics. Adherence to codes of conduct. Most professionals are bound by codes of conduct set by their respective professional bodies. These codes emphasize honesty, integrity, and putting the client's, in this case, the state's, interests first. Consequences of ethical breaches. if a professional is found to have breached their ethical obligations, they could face disciplinary actions from the governing bodies. This might include suspension of their license to practice, fines, or expulsion from their professional association. 2. Conflict of interest. Avoiding bias. It is ethically incumbent upon these professionals to avoid conflicts of interest. For example, if a legal advisor or financial consultant had a personal or financial interest in the contract, this would constitute a serious ethical violation. Transparency. Professionals must disclose any potential conflicts of interest to the government before entering into an advisory or facilitation role. Failure to do so could result in disciplinary action or legal consequences. 3. Accountability to the public. Public trust. Those who represent the state are accountable not just to the government, but to the public as well. They must ensure that their actions serve the public interest and do not cause harm to the state or its citizens. Restoring trust. In cases where their actions have led to detrimental outcomes, professionals have an ethical responsibility to help rectify the situation, whether by cooperating with investigations or offering solutions to mitigate the damage. Consequences of failing to uphold responsibilities. 1. Professional disciplinary actions. Licensing and certification. Professionals may lose their licenses or certifications if found guilty of misconduct or ethical breaches. This could effectively end their careers in their respective fields. Reputation damage. Even if legal consequences are avoided, the damage to a professional's reputation can be irreparable. Public exposure of their involvement in detrimental contracts could lead to a loss of clients, employment opportunities, and trust. 2. Legal repercussions. Criminal convictions. As mentioned, criminal behavior such as fraud or corruption can lead to imprisonment and significant fines. Civil suits. Those found negligent or in breach of their duties may face civil lawsuits, which could result in substantial financial penalties and compensation to the state. Conclusion of the answer to question 2. The importance of vigilance and integrity. Professionals representing the government in contract negotiations have a profound responsibility to act in the best interest of the state and its people. Legal and ethical accountability ensures that they perform their roles with the highest standards of integrity, diligence, and transparency. When these responsibilities are neglected, the consequences can be severe, both for the state and for the individuals involved. It is essential that all professionals engaged in such roles remain vigilant and committed to upholding the trust placed in them by the public. Question number 3. Should shareholders, financial consultants, transaction advisors, accountants, financial advisors, and lawyers representing the companies involved in securing these detrimental agreements be held responsible for their roles? What are the potential consequences and liabilities they might encounter for facilitating such contracts? Responsibility of company representatives in detrimental agreements. When companies secure agreements with the government that are later found to be detrimental to the state, it's not only the state representatives who face scrutiny. Shareholders, financial consultants, transaction advisors, accountants, financial advisors, and lawyers representing these companies also bear significant responsibility. Let's explore whether they should be held accountable for their roles and the potential consequences and liabilities they might encounter. Here we have discussed the following matters. Accountability of company representatives, potential consequences and liabilities. Accountability of company representatives. Ethical and legal responsibility. Duty to act lawfully. All professionals involved in securing government contracts, including those representing private companies, have a legal and ethical duty to act lawfully and ethically. This includes ensuring that the contracts they help negotiate or secure are fair, transparent, and in compliance with all applicable laws and regulations. Ethical standards. Lawyers, accountants, and financial advisors are bound by professional codes of ethics. These standards require them to avoid any actions that could harm the public interest or lead to illegal or unethical outcomes. 2. Shareholders' role. Active shareholders. Shareholders who are actively involved in decision-making processes may be held accountable if they knowingly approved or pushed for agreements that are detrimental to the state. Indirect responsibility. Even shareholders who are not directly involved in the day-to-day operations can face reputational damage or financial consequences if the company's actions lead to legal challenges or penalties. 3. Advisors and consultants. Financial and transaction advisors. These professionals are responsible for providing sound financial advice and structuring deals that are in the best interest of both the company and the state. If they fail to do so, they may be held liable for professional negligence or misconduct. Lawyers and legal advisors. Legal advisors are expected to ensure that contracts are compliant with all relevant laws and do not violate public policy. If they fail to identify or address issues that render the contract detrimental to the state, they could face disciplinary action from legal governing bodies and potentially be sued for malpractice. Potential consequences and liabilities. We will discuss the following. 1. Professional liability. 2. Criminal liability. 3. Reputational damage. 4. Professional disciplinary actions. 5. Financial consequences. 1. Professional liability. Negligence claims. Professionals like financial advisors, accountants, and lawyers may face negligence claims if their actions or advice contributed to a contract that is harmful to the state. Companies or the state could sue them for damages resulting from their advice or actions. Breach of fiduciary duty. Lawyers and financial advisors owe a fiduciary duty to their clients, including the responsibility to act in their best interest. If they breach this duty, they could be held liable in civil court for any harm caused. 2. Criminal liability. Fraud and corruption. If there is evidence that any of these professionals engaged in fraudulent activities, such as bribery or falsification of documents, they could face criminal charges. This might include imprisonment, fines, and a permanent criminal record. Aiding and abetting. Even if a professional did not directly engage in illegal activities, they could still be charged with aiding and abetting if they knowingly facilitated or turned a blind eye to actions that led to a detrimental contract. 3. Reputational damage. Loss of professional standing. Being involved in a scandal related to a detrimental contract can severely damage a professional's reputation. This can result in the loss of clients, employment opportunities, and professional relationships. Public backlash. Companies and professionals involved in such agreements may face significant public backlash, leading to long-term damage to their brand and credibility. 4. Professional disciplinary actions. Legal sanctions. Lawyers and accountants who violate ethical or legal standards may face disciplinary actions from their respective governing bodies. This could include suspension or revocation of their licenses, fines, and other penalties. Financial advisors. Financial advisors who engage in unethical behavior may also be sanctioned by regulatory bodies, leading to loss of certification and the ability to practice in their field. 5. Financial consequences. Fines and penalties. Companies and their representatives may face substantial fines if found guilty of facilitating a detrimental contract. This can include punitive damages in civil cases or regulatory penalties. Restitution. Courts may order those responsible to pay restitution to the state for any financial losses incurred due to the contract. This could involve significant sums of money, depending on the scale of the harm caused. Conclusion to answer to question 3. The imperative of ethical conduct. Professionals and shareholders representing companies have a critical responsibility to ensure that their actions do not result in harm to the state or public interest. The potential consequences of facilitating detrimental agreements are severe, ranging from legal and financial penalties to lasting reputational damage. Upholding ethical standards and conducting thorough due diligence is not just a legal requirement, but a moral obligation for all involved. It is essential for these professionals to act with integrity, transparency, and a commitment to the greater good, ensuring that their work benefits both their clients and the public. Question 4. What were the responsibilities of the people in power at the time, including the members of the respective cabinets who approved these agreements, if such approval was required? How should they have exercised their authority to protect the state's interests, and what accountability measures should be in place? Responsibilities of the people in power, a duty to protect the state. When agreements that are detrimental to the state are made, the people in power, including cabinet members who approved these agreements, hold significant responsibility. Their role is crucial in safeguarding the interests of the state and its citizens. Let's explore the responsibilities they held, how they should have exercised their authority, and what accountability measures should be in place to prevent such situations. Here, we have discussed the following matters. Key responsibilities of leaders and cabinet members exercising authority to protect the state's interests. Accountability measures for leaders and cabinet members. Key responsibilities of leaders and cabinet members. Here the following matters have been discussed. 1. Due diligence and informed decision-making. 2. Upholding the public interest. 3. Legal and ethical integrity. 4. Strategic vision and long-term planning. Due diligence and informed decision-making. Thorough analysis. It was the duty of the leaders and cabinet members to thoroughly analyze the terms and implications of any agreement before giving approval. This involves understanding the legal, financial, and social impacts on the state. Seeking expert advice. They should have consulted with legal experts, financial advisors, and other professionals to ensure that the agreement was in the best interest of the state. Ignoring expert advice or failing to seek it altogether would constitute a breach of the duty to the public. 2. Upholding the public interest. Prioritizing the nation's welfare. Leaders and cabinet members are entrusted with the responsibility to prioritize the public interest over any personal or political gains. They should have ensured that the agreements were beneficial to the state and did not jeopardize its financial stability or sovereignty. Transparency in decision-making. Decisions involving state resources should be made transparently, with clear communication about the reasons behind the approval of any agreements. This transparency builds public trust and accountability. 3. Legal and ethical integrity. Compliance with laws and regulations. It was their responsibility to ensure that all agreements complied with national laws, regulations, and policies. They should have been vigilant in identifying any legal red flags that could indicate the agreement was not in the state's best interest. Ethical conduct. Leaders and cabinet members were expected to act with integrity, avoiding any conflicts of interest or unethical behavior. This includes resisting undue influence from private entities or individuals seeking to benefit from the agreement. 4. Strategic vision and long-term planning. Considering long-term impacts, leaders should have evaluated not only the immediate benefits but also the long-term consequences of the agreements. This includes assessing how the agreements would affect future generations and the overall stability of the state. Safeguarding national assets. They had the duty to protect national assets and resources from exploitation or mismanagement through poorly conceived agreements. This involves ensuring that state resources are used effectively and responsibly. Exercising authority to protect the state's interests. Here, we have discussed the following matters. 1. Rigorous approval processes. 2. Oversight and monitoring. 3. Public consultation and engagement. Rigorous approval processes. Establishing clear criteria. Before approving any agreement, leaders should have established clear criteria to assess its benefits and risks. This includes financial viability, legal soundness, and alignment with national priorities. Ensuring accountability in decision-making. Decision-making should have been a collective process, involving multiple levels of review and approval to prevent unilateral decisions that could harm the state. 2. Oversight and monitoring. Continuous monitoring. Once an agreement was approved, it was essential for leaders to ensure continuous monitoring of its implementation. This would help in identifying and addressing any issues early on, before they could cause significant harm. Regular reporting. Leaders should have required regular reporting from all parties involved in the agreement to ensure transparency and accountability in its execution. 3. Public consultation and engagement. Engaging stakeholders. For agreements with significant public impact, leaders should have engaged with stakeholders, including the public, civil society, and relevant industries, to gather input and build consensus. Ensuring public awareness. Transparency involves keeping the public informed about major agreements, particularly those involving state resources. Public consultations and disclosures could have helped in identifying potential risks before the agreement was finalized. Accountability measures for leaders and cabinet members. Here we have discussed the following matters. 1. Legal accountability. 2. Political accountability. 3. Administrative accountability. Legal accountability. Judicial scrutiny. Leaders and cabinet members who approved detrimental agreements should be subject to judicial scrutiny if there is evidence of negligence, misconduct, or corruption. This could involve criminal charges, civil suits, or other legal actions. Consequences for breach of duty. If found guilty of breaching their duties, they should face appropriate legal consequences, including fines, imprisonment, or disqualification from holding public office. 2. Political accountability. Answerability to the public. Political leaders must be accountable to the public for their decisions. This could involve inquiries, public hearings, or parliamentary investigations to determine their role in approving detrimental agreements. Electoral consequences. Leaders who fail to protect the state's interests should face electoral consequences, including being voted out of office or being barred from future political participation. 3. Administrative accountability. Internal investigations. Government bodies should conduct internal investigations to determine if proper procedures were followed in the approval of the agreements. If lapses are found, responsible officials should be disciplined or removed from their positions. Reforms and safeguards. To prevent future occurrences, administrative reforms should be implemented, including stricter approval processes, enhanced transparency, and stronger checks and balances. Conclusion to answer to question number 4. The imperative of responsible leadership. The responsibility of leaders and cabinet members in approving agreements is profound and cannot be taken lightly. They are entrusted with the welfare of the state and its people, and their decisions can have far-reaching consequences. It is essential that they exercise their authority with the utmost diligence, integrity, and transparency, ensuring that all agreements serve the public interest and protect the state's future. When they fail in these duties, robust accountability measures must be in place to address any harm caused and to reinforce the importance of responsible governance. Question number 5. Can the Supreme Court of Pakistan take suo motu action upon becoming publicly aware of agreements that are detrimental to the state? What legal basis and precedents exist for the court to intervene in such matters to safeguard public interest? Supreme Court's suo motu powers. Protecting the state and public interest. The Supreme Court of Pakistan plays a crucial role in upholding justice, safeguarding public interest, and ensuring that the actions of the state align with the Constitution and legal principles. One of the powerful tools at its disposal is the ability to take suo motu action. But what does this mean? And under what circumstances can the court intervene when agreements detrimental to the state come to light? Let's explore the legal basis, precedents, and implications of such actions. We have discussed the following matters. Understanding suo motu powers of the Supreme Court. Precedents for suo motu intervention in Pakistan. Implications and outcomes of suo motu actions. Understanding suo motu powers of the Supreme Court. 1. What is suo motu action? Definition. Suo motu, a Latin term meaning on its own motion, refers to the power of the Supreme Court to initiate legal proceedings on its own, without a formal petition from any party. This power allows the court to address issues of significant public importance, particularly when fundamental rights or the public interest are at stake. Why it matters? Suo motu actions enable the court to act swiftly in situations where there is an urgent need to protect the state or public from harm, especially in cases where no one else has brought the issue to the court's attention. 2. Legal basis for suo motu action. Article 184(3) of the Constitution of Pakistan. This article grants the Supreme Court the jurisdiction to take suo motu notice of matters involving a question of public importance with reference to the enforcement of fundamental rights. This is the primary legal basis for the court's ability to intervene in cases where state agreements may harm the public interest. Protection of fundamental rights. The court's intervention is justified when an agreement or state action threatens fundamental rights such as the right to life, property, or equality before the law. These rights are enshrined in the Constitution and form the foundation of the court's power to act. Precedents for suo motu intervention in Pakistan. 1. Landmark cases. RPP, Rental Power Projects, case. In this high-profile case, the Supreme Court took suo motu notice of irregularities and corruption in rental power projects that were detrimental to the state. The court declared the contracts illegal, highlighting the importance of transparency and accountability in state agreements. LNG import case. The Supreme Court also took suo motu action in cases involving the import of liquefied natural gas, LNG, where it was alleged that the contracts were not in the public interest. The court's intervention underscored its role in scrutinizing government contracts that have far-reaching implications for the country. 2. Criteria for suo motu action. Public importance. The court typically intervenes when the matter is of significant public importance. This includes situations where the state's financial stability, national security, or public welfare is at risk due to a detrimental agreement. Violation of law or constitution. The court is more likely to take suo motu action when there is a clear violation of the law or constitution, such as agreements that are ultra vires, beyond the powers of the government, or that contravene public policy. Implications and outcomes of suo motu actions. 1. Judicial review of state agreements, scrutinizing legality. Suo motu actions allow the Supreme Court to scrutinize the legality of state agreements, ensuring that they comply with the law and do not harm public interest. This can lead to the nullification of contracts that are found to be illegal or unconstitutional. Ensuring accountability. By taking suo motu action, the court can hold public officials and private entities accountable for their roles in facilitating detrimental agreements. This may result in criminal prosecutions, financial penalties, or administrative actions against those responsible. 2. Protecting public interest, safeguarding state resources. The court's intervention helps protect state resources from being squandered or misused in agreements that are not in the best interest of the country. This is particularly important in cases involving significant financial or strategic assets. Restoring public confidence. Suo motu actions also play a critical role in restoring public confidence in the judiciary and the rule of law. When the court steps in to correct wrongs that affect the nation, it reinforces the idea that justice will be served, even in the absence of a formal complaint. 3. Legal and policy reforms, guiding future conduct. The precedents set by the Supreme Court in suo motu cases often lead to legal and policy reforms. These reforms can include stricter guidelines for government contracts, enhanced transparency measures, and improved oversight to prevent similar issues in the future. Conclusion to the answer to question number 5. The Supreme Court's role in safeguarding the nation. The Supreme Court of Pakistan's ability to take suo motu action is a powerful tool for protecting the state and public interest, especially when agreements that threaten the nation's welfare come to light. By invoking its suo motu powers, the court ensures that no harmful action goes unchecked, even in the absence of a formal petition. The legal basis for such interventions is rooted in the Constitution, and the court's past actions have set important precedents for holding both public and private entities accountable. This vigilant oversight is essential for maintaining the rule of law and ensuring that the state acts in the best interests of its people. Question number 6. What steps should the public, legal professionals, and bar councils take to protect the public from the adverse effects of agreements that are detrimental to the state and its people? How can they effectively challenge such agreements and hold those responsible accountable? Protecting the public, a collective responsibility. Agreements that are detrimental to the state not only harm the nation's financial and social fabric but also erode public trust in governance. It is the collective responsibility of the public, legal professionals, and bar councils to take proactive steps to protect the public from such adverse effects. Let's explore how they can effectively challenge these agreements and hold those responsible accountable. We have discussed the following matters. Steps for the public. Awareness and advocacy role of legal professionals, guardians of justice, bar councils, advocates for public interest. Steps for the public, awareness and advocacy. 1. Raising public awareness, informed citizenry. The public plays a crucial role in ensuring transparency and accountability. Citizens should stay informed about government agreements, contracts, and policies that may affect the state and its people. Knowledge is power, and an informed public can serve as a powerful check on government actions. Utilizing media and social platforms. Public awareness can be amplified through media campaigns, social media platforms, and community discussions. By spreading information and engaging in dialogues, the public can draw attention to potentially harmful agreements and demand accountability. 2. Civic engagement. Public protests and petitions. When detrimental agreements are discovered, the public has the right to organize protests, sign petitions, and voice their concerns. These actions can pressure government officials to reconsider or revoke such agreements. Demanding transparency. The public should demand greater transparency in government dealings, including the publication of contract details, bidding processes, and decision-making criteria. Transparency is key to preventing agreements that favor a few at the expense of the many. 3. Supporting legal challenges. Backing legal actions. The public can support legal professionals and organizations that challenge detrimental agreements in court. This can include contributing to legal funds, participating in class action lawsuits, or providing evidence and testimony. Engaging civil society. Civil society organizations, NGOs, and advocacy groups can be instrumental in mobilizing public support, conducting independent investigations, and holding authorities accountable. Role of legal professionals, guardians of justice. 1. Proactive legal advocacy. Challenging unlawful agreements. Legal professionals have a duty to challenge agreements that are illegal, unconstitutional, or against public policy. By filing public interest litigation, PIL, or representing affected parties, lawyers can bring these issues to the judiciary's attention. Providing pro bono services. To ensure that access to justice is not limited by financial constraints, legal professionals should offer pro bono services to those impacted by detrimental agreements. This helps in leveling the playing field and ensuring that justice is accessible to all. 2. Legal education and public engagement. Educating the public. Lawyers and legal scholars should engage in public education initiatives to explain the legal implications of harmful agreements. Workshops, seminars, and public lectures can empower citizens with the knowledge they need to protect their rights. Publishing legal analyses. Legal professionals should publish articles, op-eds, and research papers analyzing detrimental agreements, highlighting the legal flaws and proposing solutions. This not only informs the public but also provides a basis for legal action. 3. Collaboration with bar councils. Forming legal task forces. Bar councils and legal associations can form special task forces to investigate, monitor, and challenge detrimental agreements. These task forces can work on gathering evidence, providing legal representation, and advocating for policy changes. Supporting judicial accountability. Legal professionals should work with bar councils to ensure that judges and courts are empowered to take action against detrimental agreements. This includes advocating for judicial independence and resisting any attempts to undermine the judiciary. Bar councils, advocates for public interest. 1. Leading the charge on legal reforms. Advocating for stronger laws. Bar councils should push for legal reforms that prevent detrimental agreements. This could include advocating for stricter procurement laws, transparency regulations, and stronger penalties for corruption and misconduct. Enhancing oversight mechanisms. Bar councils can work to strengthen oversight mechanisms within the legal and governmental systems. This includes pushing for the establishment of independent regulatory bodies to monitor government contracts and agreements. 2. Disciplinary actions against misconduct. Holding lawyers accountable. If legal professionals are found to have facilitated or been complicit in harmful agreements, bar councils should take disciplinary action. This might include suspending licenses, imposing fines, or disbarring individuals from practice. Promoting ethical standards. Bar councils should promote high ethical standards within the legal profession, emphasizing the importance of serving the public interest and upholding justice. 3. Public interest litigation and legal support. Initiating PILs. Bar councils can initiate public interest litigation on behalf of the public, challenging detrimental agreements that harm the state or violate constitutional rights. Providing resources and support. Bar councils should provide resources, legal aid, and support to lawyers and organizations that take on cases related to detrimental agreements. This helps in building a strong legal front to protect the public. Conclusion to answer of question number 6. A unified front for justice. The battle against detrimental agreements that harm the state requires a unified effort from the public, legal professionals, and bar councils. Each group has a vital role to play in challenging these agreements, holding those responsible accountable, and ensuring that the state's interests are protected. By raising awareness, engaging in legal advocacy, and pushing for reforms, we can create a system where transparency, accountability, and justice prevail. Together, we can safeguard the nation from agreements that compromise its future and ensure that the public interest is always at the forefront. Thank you for watching. Thank you for watching and considering this critical issue. I am not a lawyer, and the information presented in this video is based on AI-generated content. I intend to highlight a concern that warrants serious discussion among Pakistan's legal professionals and state authorities. I strongly encourage the relevant legal experts to explore this matter further and take the necessary steps to ensure that the interests of the state and its people are protected. Your insights and expertise are crucial in addressing this issue appropriately.